Get ready for the dictation in 3, 2, 1, start. Undisputedly, the petitioners were juveniles at the time of the incident, which allegedly took place in September 2001. Stop. By that time, the Juvenile Justice Board concluded the inquiry. The petitioners had crossed the age of juvenility by a comfortable margin. Stop. The Juvenile Justice Board at para 30 of its judgment observed that an order under section 15 of the act could even be passed against a person who had crossed the age of juvenility during the inquiry and thereafter ordered that the accused be sent to the special juvenile home fit institution declared by the state government. Stop. The appellate court confirmed the said judgment being aggrieved, whereby this revision has been preferred. Stop. The petitioners are presently confined at the special juvenile home. Stop para. Miss Manju Chaudhary, learned counsel for the petitioners, relied on the Honorable Supreme Court judgment in the case of Bhoop Ram versus State of UP reported in AIR 1989 SC 1329 under bracket 1 and the order dated 4/3/2015 passed by this court in SB Criminal Revision Petition number 135/2015 bracket Setha Ram versus the state of Rajasthan bracket close and urged that as the petitioners had crossed the age of juvenility by a significant margin of almost 5 years by the date of conclusion of inquiry, the Juvenile Justice Board could not have directed them to be sent to the special home fit institution. Stop. She thus urged that the revision be accepted and the order passed by the courts below directing that the petitioners be sent to the special home fit institution should be set aside and they should be ordered to be released from confinement forthwith. Stop para. Learned public prosecutor and the learned counsel for the complainant, on the other hand, vehemently opposed the submissions advanced by the petitioner's counsel and contended that the petitioners were convicted by the Juvenile Justice Board for the heinous offense of rape and murder of a minor child, and as such the board, after finding the petitioners guilty of the charges, was perfectly justified in directing that they be kept at the special home fit institution for a period of 3 years. Stop. They thus urged that the revision is devoid of any merit and should be rejected. Stop. Para. I have heard the arguments advanced by the learned counsel for the parties and have gone through the material available on record. Stop. Para. The Juvenile Justice Board can, upon concluding an inquiry against a delinquent juvenile, only pass such orders which are prescribed by section 15 and 16 of the Juvenile Justice Act, which read as below. Order that may be passed regarding juvenile, where a board is satisfied on inquiry that a juvenile has committed an offence, then, notwithstanding anything to the contrary contained in any other law for the time being in force, the board may, if it so thinks fit, allow the juvenile to go home after advice or admonition, following appropriate inquiry against and counseling to the parent or the guardian, and the juvenile direct the juvenile to participate in group counseling and similar activities, order the juvenile to perform community service, order the parent of the juvenile or the juvenile himself to pay a fine if he is over 14 years of age and earns money, direct the juvenile to be released on probation of good conduct and placed under the care of any parent, guardian, or other fit person, on such parent, guardian, or other fit person executing a bond with or without surety as the board may require for the good behavior and well being of the juvenile for any period not exceeding 3 years, direct the juvenile to be released on probation of good conduct and placed under the care of any fit institution for the good behavior and well being of the juvenile for any period not exceeding 3 years, make an order directing the juvenile to be sent to a special home for a period of 3 years, provided that the board may, if it is satisfied that having regard to the nature of the offence and the circumstances of the case, it is expedient so to do for reasons to be recorded, reduce the period of stay to such period as it thinks fit. Stop. Thank you.